Thank you so much for watching this follow-up video to my video about raising capital for worker co-ops. Since we made that video, I discovered some new things, and there have also been some new developments that I'd like to tell you about. First of all, in that video, I had recently learned about a case about the Silver Hills Country Club and the fact that some people had pre-sold memberships in a country club and there was no financial return offered, and yet the California Supreme Court still considered that to be a security. At the time, I wasn't sure if the definition of a security was really that broad under California law, not to mention about 17 other states that have adopted a similar test, which is called the risk capital test. And I've since found out that unfortunately, yes, it is true that in those states that have adopted that test, the definition of a security is quite broad. So when people do things as a way to get around the securities law because by not offering any financial return, that works really well under federal law and also under the states that have not adopted the risk capital test. But in California and many other states, the definition is much broader. So if you were to pre-sell a gift card or pre-sell produce, or if you were to borrow money and say, I'm not providing any interest on the loan, that still could be considered a security under state law. So unfortunately, this means that in California and other states that have adopted the same test, we need to be very, very careful about how we raise money to make sure that we don't fall within the definition of a security and then we don't comply with all of the securities requirements and get into trouble. Now, there is one thing you can do to try to address this problem, because it's really frustrating to not be able to use these tools to raise capital. And I have done this in another state. I haven't yet done it in California, so I'm not sure how long it would take or how much effort it would take to deal with the California securities regulators on something like this. But what you can do is send them a letter. We call it a request for no action letter. And you describe in the letter what it is you want to do. And you ask them, can you let us know if you would take enforcement action against us under the securities laws if we did this. So hopefully that way, if you want to do something like a pre-sale of something and you're pretty sure that it's probably not going to be considered a security, but you want to make 100% sure, this would be the way to do that. So basically what this rule says in California, called the risk capital test, is that securities laws can apply even when you're not offering financial return at all, if you're offering the opportunity to the public and the people who are investing have no control over the success or failure of the business, and there's no security for the money they're investing. There's no collateral. So they could lose all their money and not get the thing that they're expecting in return, whether it be coffee from your coffee shop, a return of their principal, etc. The other thing I want to clarify is that a couple times in the earlier video, I quickly said something like, oh, in that case, the federal securities laws wouldn't apply. So for example, if you are able to take advantage of the interstate exemption from the federal securities registration requirements, that I said the federal securities laws wouldn't apply. Now, I just want to clarify that that's not exactly right. There are still federal securities laws that will apply even when you're using the interstate exemption from the registration requirements. So some examples of those federal laws that would still apply are there is under the 1934 Securities and Exchange Act, if you have more than 500 investors in a single class of equity stock or an ownership interest in your company, you automatically become what they call a public reporting company. And a public reporting company is subject to a lot of compliance requirements, quarterly filings that need to be made, reports that need to be made to your investors. So you need to be careful not to go over 500 in any one class of equity securities. Another federal law that applies is the federal government will still be interested if fraud gets committed. So even if you're not subject to the federal registration requirements, you still could get some federal enforcement action if you commit fraud in the offering of your securities. Now, I also want to correct something that I think I misstated in the initial video, and that was I was talking about something called a California Capital Access Company. So a California Capital Access Company is a fairly new thing that can be created under California law, and as far as I know, there still isn't one that's actually been created. And in the video, I said that the securities in that fund could actually be sold to the public. And that is true, but what I didn't say is that they can only be sold to accredited investors. So only wealthy investors can invest in California Capital Access Companies. The last thing I want to tell you about is some really exciting developments that have happened in the area of securities law. Now, as you know, it's incredibly frustrating for businesses of all kinds to have to deal with these rules when they're only trying to raise a fairly small amount of money. If you're trying to raise, $100,000, $200,000, and you have to spend $20,000 in legal fees just to be able to raise the money, it's pretty much impossible. And so it puts small businesses of all kinds into a really difficult situation and makes it, many of them just can't start up at all because they have absolutely no way to raise capital in a way that's legal. So last summer in July of 2010, the Sustainable Economies Law Center that I'm the co-director of wrote a letter to the Securities and Exchange Commission to ask for an exemption to this general rule and said, could we possibly create an exemption for very small investments of up to $100 per investor with a maximum of $100,000 total. Now we know that's a fairly small amount of money, but we just really wanted to kind of make the point to the SEC, isn't it silly that even if that's all I'm trying to raise, even then I can't do it without spending tens of thousands of dollars on legal fees. So when I spoke in the full video, nothing really had happened. The movement had grown, a lot of people had talked about this issue and gotten excited about it. But more recently, there have been congressional hearings on the topic. There has actually been a House bill introduced that would legalize what they call crowdfunding, which basically means a large number of small investments. And what this congressperson is proposing in the bill would actually would completely exempt securities offerings of up to $5 million where each investor doesn't put in any more than $10,000. So this is way more than we asked for, which is kind of exciting. Also in the proposed legislation, the cap of 500 investors that I mentioned before would actually not apply to this type of crowdfunding activity. And you would also be exempt from the state level registration requirements. You might still have to do some filings at the state level, but they would be very simple notice filings. So this is pretty exciting. Also, President Obama, right around the same time this bill was introduced by a Republican congressperson, in his big job speech in early September, he actually announced his intention to get rid of the red tape that makes it so hard for people to raise money, for small businesses to raise money. And he announced a very similar crowdfunding exemption to the one that's being proposed by this Republican congressperson. So this is one of those rare cases where the Republicans and Democrats seem to agree. We don't know how long it will take to actually go into effect and what it will look like when it goes into effect. For all we know, they may lower these numbers, they may make some changes. The Securities and Exchange Commission may add some complications to the requirements, but hopefully within not too long, we will see some really exciting opportunities for worker co-ops, artists, filmmakers, small businesses of all kinds to actually be able to raise money without having to spend all kinds of money on armies of lawyers and accountants to make it legal.